Hi, I'm Alex Kennedy. I'm a disputes and employment solicitor here at Gannon's, and I'm here to talk to you about settlement agreements. A settlement agreement is a contract by which one party agrees to waive some legal claim that they may have in exchange for something else, usually money. They commonly arise in an employment context. Employees have certain statutory protections, such as protections against unfair dismissal or protections governing how they can be made redundant. So when an employee leaves an employer, there are commonly these statutory rights that the employee has that the employer would like the employee to waive. And of course, what is also very common in an employment context is that the employee will receive some sort of enhanced termination payment or enhanced redundancy payment. Settlement agreements can therefore be used even if the dismissal or termination is not particularly contentious. Settlement agreements are creatures of statute, and so to be effective, certain statutory conditions must be met. Some of these are very basic. The agreement has to be in writing. It has to specify that it is a settlement agreement and that it is designed to settle particular claims. An important requirement of a settlement agreement is that the employee takes independent legal advice, and so they understand the effect of the settlement agreement. The settlement agreement will usually include what's called an advisor's certificate, where the solicitor providing the advice confirms that they have given advice on a particular date, and they also confirm that they have sufficient insurance in place to cover the advice that they have just given. Because the settlement agreement requires that the employee takes independent legal advice, it is usual that the employer will contribute to the legal fee. The amount of that contribution can vary enormously. Typically, we see figures of around £500 plus VAT, but they can be higher. They're usually not they're usually not lower than that. One question we're often asked is, to what extent should the employee negotiate the settlement agreement? Now, this will almost always depend on the circumstances. Where an employee has a particularly strong claim, it can be worth negotiating a settlement. And we've had a number of cases where we've been able to negotiate a settlement agreement or renegotiate a settlement agreement so that the package that the employee received at the end of the day was much more enhanced as compared to the settlement that was offered originally. Negotiating a settlement agreement might not just be a question of monetary value. You might negotiate a settlement agreement, for instance, to ensure that a particular reference is given by the employer, or you might negotiate the inclusion of a share plan or a bonus that wouldn't otherwise have been provided under the original settlement agreement. If you have an employment dispute, can you ask for a settlement agreement? There's no right to receive a settlement agreement. It's something that has to be agreed between the employer and the employee. However, we do sometimes find that where we are conducting an employment dispute, it is helpful to propose a settlement agreement on what's called a without prejudice basis. This means that the fact you have asked for a settlement can't be referred to in court or in open court. In practice, HR managers will often know that once a grievance is raised, the employee is really asking for a settlement. So it's not uncommon for a grievance procedure to be run alongside the negotiation of a settlement agreement. And we at Gannon's can assist with both the grievance and with the negotiation of the settlement. I hope you find that useful. If you still have any questions, or importantly, if you need to get that crucial solicitor's sign-off on a settlement agreement, please do get in touch.